Yes. No, if it is part hard, I cannot take up this matter. Try to appreciate my predicament. Sorry, if it is part hard, I cannot take up. How can I? No, sorry. I have refused your prayer yesterday. Yes, please call the list.
My lord, item number 93, my lord, of today's list, my lord. My lord, this is regarding, my lord, the technical error of 9-10, my lord. Examination is on 7th, my lord. My lord, kindly take up this matter today, my lord. Otherwise, the matter become infectious.
Technical?
Technical glitch. My petitioner medium of instruction is Bengali, but inadvertently it is selected English, my lord. In 11
Inadvertently selected
English medium of instruction.
petitioner applied as English as medium of instruction, but it is Bengali.
But by it is petitioner's medium of instruction is Bengali. Like they have given the edit option of the name, date of birth, but my lord, this edit option is not given, my lord. Though petitioner made representation and visit to the office of the commission, but it is not given, my lord.
Well, Mr. This is no problem. He. See, no, the client.
No, he.
When she goes, although others say,
Yes, he works hard.
she works not only hard, she takes all my bills, take my iPad. No, you will not carry. You sit down here.
When yesterday I was rising at 4:30, she tried to mention this matter.
There is not a problem, but you can allow it. And that in Bengali, you can go, you can appear in, you can.
Well, after finishing off up to 20, up to this. 24. This matter will be taken up out of town.
And another matter. My lord, another matter is there, my lord, though it is not in the list. Same problem, my lord. Medium of instruction.
But not in the last list, I cannot.
My lord, yesterday, my lord, try to take the leave, my lord, but my lord.
You have got the admit card, na?
Yes.
Go and sit there.
OMR sheet have to fill up.
You don't have any problem. There will be 2 languages.
No, OMR sheet likhte hobe medium of instruction.
Very well. At 2 p.m. Publish a list. Publish a list at 2 p.m.
Okay, my junior will be there. He will not be having difficulty.
Grateful.
Publish a list at 2 p.m.
Genuine cases, these are genuine cases.
We call the list.
Item number 1 to 24.
Are you in the Tainted list?
No, I am same order. Your lordship kindly record that.
So let all the matters be taken together. Why one after another? Because all these matters have to be are covered by the decision in Sampag House. If all are coming under the same category, that all are in the Tainted list from item number 1 to 24.
Yes.
All are in the Tainted list.
They are claiming they should be untainted. I am just requesting him. Better why you
requesting Mr. Ghosh mentioned this matter on 4 occasions. First, he is junior, and then
I am saying charging here, getting dismissed, go to Supreme Court and you are past. But my lord, what I am saying, I drafted the lordship's line. That's why you have to come when your lord name was not saying.
Yes.
That is my whole argument in the but because I worked, I had it, I copy from the article. You must get it all before the expiry of the pen. Before the expiry of the pen, court passed the order. My name was recommended. RTI information was given in 2018. Everything in my favor. But you are also not seeing decision over the matter. Go. If you can get
that, Mr. Bandyopadhyay can tell, but this court cannot.
No, that. If you can get at all.
One matter. High Court should told that the proceeding to remain open for adjudication by the High Court. That they are tainted or not tainted.
Which one?
You will remain back.
Yes. Which packet? Which packet?
Verifying.
Which number?
Huh?
Which one? Pronouncement. Have you filed a petition? What is the number?
You went to the Supreme Court.
Seven?
I got that.
Oh.
That is the good. But only I am submitting on client to whether my client will go or not, I don't know. I will record that that is good service on page 46. One, they supplied the information from their record, not the CBI record. That he has been given 6 categories of marks. I record this only in my 46. Page 46. That was given after my application of 2018. This guy was given.
Yes, subject marks, then academic, then PT.
Yes, then how all before this plan. So I have not given the bad governance. It is at least 2 years I have not given the bad governance.
I have held in my judgment that these are all the reasons are not confined to 3 reasons as delineated in paragraph 363 subparagraph 4. So these are illustrative, not exhaustive.
What
These are the
is showing?
only Malakali record this so that he can take it or that is
No. What is showing? That's all. That is, you see, 14th August 2018. Long before the CBI had
Yes,
taken the.
that is the record of the food service commission. Mr. Bandyopadhyay kindly consider.
Excuse me, sir. Bolne dona, Baba. No. That our record was not accepted. CBI record has been accepted. Then I have to go by the CBI record. This record has no value now. I have to go by the CBI record. That's the
Kindly record.
Item number 4. Have also got to judgment. You have to clear out the lost key name. One department it is not clearly contributing. May I submit this? Appeal is pending today. This expedition could be sent.
No, if order comes from appeal, otherwise I can. Your junior mentioned this matter. If you obtain an order from appeal court, then and there I will. But today it is not possible.
This here was made by Mr. Jurisdictional to the division bench. The division bench has rejected that, yeah, it is there.
Unless the other single judge releases the life and take.
No, how many?
Or not, not.
Besides, question of other.
Then same treatment can be extended to other matters also. It is not the practice. If you obtain an order, place it before this court, I can. Otherwise, no. Sorry.
Item number 4.
Yes, move it.
Please come to me.
এই কোডটা দাও।
কোডটা কি নাম? এই কি নাম?
Page 46.
It's number 4.
Please come to one, please note that paragraph 27 at page 60. Page 64. 6. That's the the quotation from an affidavit of 27 September 24. Please come to the last sentence of the quoted quotation. However, as the sentence beginning with the words however as the CBI has not disclosed the details with regard to the said illegal appointments detected by them to the chairman and or the secretary of the commission is not in a position to state the number of such illegal recommendations and or furnish the details of such candidates. That was a petition. Please come in an application filed before the Honorable Supreme Court by SSC, at page 84.
Mr. Mujumdar, I have considered this judgment dated 22nd April 2024 in my own way. Now, this list has been published in terms of the order passed by the Honorable Supreme Court. Case to case basis, it is not possible. It has to be on subjective satisfaction. Yes. It has to be on subjective satisfaction. At this stage, it is not possible for this entire list is to be considered separately.
My lord, just Mr. Mujumdar, just one minute. My lord, I
Yes,
yes,
yes.
there. I am believing all my argument are same and the same judge.
We are accepting that.
Only, we are just talking about 2 pages, but we don't find page to not disorder. So pages 164 and 164.
Pages?
164 and 164.
কোনটা
Cited both. Devashish Pradhan. The order does not refer to this particular order of 10 July 2025. As by the division.
was considered.
Court has classified 3 categories of candidates which can be described as tainted candidates. But these are the 3 categories.
I have considered this in my order, specifically 363.4.
It has been considered.
Esho, please don't repeat. In all the matters, all the writ petitions are taken up together for consideration since common issues involved. Stop. Huh? Common issues, since common issues involved. But affidavit of service filed on behalf of the petitioners that are taken on record. Stop. Petition, next paragraph. Petitioners
I have not seen.
go and fight out there. Petitioner are declared as tainted candidates and their names feature in the list dated 30th August 2025. Which was published by the West Bengal Central School Service Commission. Debarring thereby stop. By publishing list dated 30th August 2025, petitioners since are termed as tainted, they will not be permitted to participate in the ensuing examination scheduled on 7th September 2025 and 14th September 2025. Stop. The examinations which are to be held on 7th September 2025 and 14th September 2025 are part of selection process which has been initiated in terms of the recruitment notification dated 30th September 2025, 30th May 2025. Being number 1092/7016/CSSC/ESTT/2025. Next paragraph. It is submitted by the learned advocates representing the petitioners. In all cases, admit cards have been cancelled. In all cases.
By virtue of the 30th August.
List.
Put item number 30 seconds.
Next, stop. তারপর কি বলছিলাম? That though they were issued admit cards permitting them to sit in the scheduled examinations, but based on list dated 30 August 2025, their admit cards are cancelled, triggering the present writ petitions. Stop. Next paragraph. Learned advocates representing the parties have relied upon judgment of the Honorable Division Bench, dated 22nd April 2025, dated 22nd April 2025. 2024 division, 22nd April 2024, 22nd April 2024, delivered by the Honorable Division Bench.
I'm taking
On a, yes, on a batch of appeals. Now, on a batch of matters, first one being WPA 306409 of 2016, within bracket Boishaki Bhattacharya, within bracket Chatterjee and others versus State of West Bengal and others, and the judgment of the Honorable Division Bench dated 3rd April 2025, delivered in civil appeal arising out of special leave petition within bracket civil close bracket 9586 of 2024 within bracket State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee and
মনে হচ্ছে ভুল দেখেছিস
stop.
লিস্টটা ভালো করে দেখে নে, মিলিয়ে নে।
Next paragraph. In addition thereto, Mr. Prahlad Ghosh, learned advocate representing the petitioner, has made submission in WPA 1991999 WPA 19994 of 2025, based on page 46, based on a document dated 29th December 2020, issued by the concerned authority of the West Bengal Central School Service Commission, whereby petitioner in the said writ petition was informed of marks allotted to him. So it is submitted that this document shows that petitioner is not a tainted candidate. Therefore, his name should not feature in the list dated 30th August 2025. Next paragraph. Mr. Shomo Mojumdar, learned senior advocate representing some of the petitioners, have has made submissions relying upon the judgment dated 3rd April 2025.
10 July 20. 10 July 2025. So I find that from a lordship's judgment because it has not gone down. Here from now. 10 July 25 has not gone down at least. What do you have thought?
That's the point even I wanted to urge in item number 2.
This is a judgment dated 3rd April 2025. Page 66.
The division bench by considering 3rd April 2025 before judgment.
Oh, that is in contempt.
3rd April 2025 is the principal order by the Honorable Supreme Court.
Yes. Thereafter, if contempt petition was filed,
Thereafter, notifications, extension, modification.
alleging violation of the order dated 22nd April 2024.
I am not on that. 10 July 2025, arising out of certain challenges thrown to the process now carried out, a reputation was taken up, which has gone up to the Honorable Division Bench.
Oh, that is against the order passed by this court in Sanjay Dolu, in Orunima Pal.
10 July 2025 records that the Supreme Court had actually made these 3 categories of candidates to tainted candidates.
Well.
Please have a look at paragraph
Which page you have annexed the judgment?
164 of that item number 4. Okay, paragraph 32 of the Honorable Division Bench order, which is not
Page.
164.
So your lordship will
Not
consider this as my submission item number 2 also. Same.
Lord,
I'll take your lordship lead.
in item number 6, Lord, your lordship will find one affidavit, Lord.
This judgment starts from which page, Mr.
It
Mudunga?
begins at page 142.
First order of the division bench. Again, in an appeal, in appeals preferred against order passed in judgment delivered in Sanjay Kumar.
7 July.
ওখানটা একটা বলো তো আরেকবার সেন্টেন্সটা বলো সৌম্য মজুমদার যেখানে বলছিলাম Mr. Somo Mujumdar, learned senior advocate, comma, Mr. Shuddha Sattva Banerjee, learned advocate, representing some of the learned advocate and other learned counsels representing the petitioners have placed reliance on the order dated 10th July 2025 or has placed reliance on judgment dated 10 July 2025 delivered on MAT 1016 of 2025 within bracket state West Bengal Full Service Commission and another versus Sanjay Kumar Doloi and others. Stop. It is argued that paragraph 163, paragraph 363, subparagraph 4, paragraph 363 within bracket 4 of the judgment dated 3rd April 2025 passed delivered by the Honorable Supreme Court in Boisakhi Bhattacharya Chatterjee Supra was considered by the Honorable Division Bench and made certain observations which come from favor of the petitioner, made certain observations which come in favor of the present petitioners in determining whether petitioners are tainted candidates or not. Stop. Next paragraph.
Not
having considered the respective submissions made on behalf of the parties, court finds that the issue involved in this writ petition has been dealt with by this court on a batch of writ petitions. First one being WPA 20845 of 2025 within bracket Shampa Ghosh versus State of West Bengal and others. So, it is found that ratio of Shampa Ghosh Supra covers the issue involved in this issue involved in the present writ petition. So, Next paragraph, placing reliance on Sampak Ghosh Shukla, writ petitions are dismissed. Urgent xerox certificate.
Deeply read.
My lord,
এই দুটোর উপরে করবে
Lord, if your lordship kindly gives one more observation, Lord.
Please call the next matter.
Lord,
এইটা রেখে দাও।
Lord, if your lordship gives one more observation, Lord, in respect of one matter, Lord.
হ্যাঁ,
My lord,
না ওটা ডেকে নাও, 101 ডেকে নাও।
may I humbly beseech one
Sorry, no further. Sorry, yes. Call the out of turn matter, item number 93.
Oh, man, out of my
101.
item number 101. এটা এখানে দিয়ে লাভ নেই, ওখানে একটা একটা করে সব দেবে। হবে হবে
Respect of poemership. That I have dealt with in Sampak Ghosh.
এটার পর হবে। ওখানে কি সব ফাইল
only one all of them in without those ones they count in the cutoff. That's the only recorder of that. Only recorder.
Lord, that has been, Lord, that has been stated by the
Please call 101.
SSC, Lord, in
item number 101.
report, Lord.
My lord, বলছি item number 2 mismatch OMR ছিল না কিন্তু।
Please call the list. I have hard and fast order in item number all matters. Yes.
বলছি petitioner হবে।
This is item number 101.
Yes, your lordship. Kindly came to page number 46. Number 1.
download করতে
Ranaji.
Affidavit of
Yes.
আমার ইয়েতে দিন।
Yes, 1015. Yes, what is your case?
Sir,
Let's your case.
sir, kindly come to my lord page number 43.
43. Medium of vacancy English that you want to appear in Bengal, not in English. You have applied in terms of 30th May 2025 recruitment notification. Where is the admit card?
Page number 43.
What is page 43?
Sir, 43 is the online application. मतलब actually what it is major application for second SLSP, for second state level selection test for recruitment of assistant teacher 2025 in class level 9 and 10 in government aided sponsored school. It is written in the top. This is online application.
চেঞ্জ করতে চেয়েছি is a mistake you say
Yeah, good.
Oh, this is your application.
Online.
In the application, why you have stated English?
In scroll down, my lord, it is inadvertently selected.
Petitioner was casually scrolling down.
Yes.
This is like scrolling down WhatsApp or Facebook.
No, my lord, it is not that.
Why this has happened?
Inadvertently.
Now, where is your admit card?
My lord, page number 44. 44 admit card 46.
It is stated that you are to participate in the examination, treating the petitioner who has applied in English.
My lord, but in admit card medium of instruction is
Not mentioned.
when the OMR sheet come to me at the time of examination.
When a OMR sheet will distribute, then you will find the OMR sheet which is in connection with your application where it is stated English.
No, my lord, in the online application, it is mentioned, OMR sheet I will get at the time of examination. When I get the OMR sheet, I have to fill up the medium of instruction. But since my lord, my application,
OMR sheet is common for English medium and Bengali medium.
Correct. There,
Permit the petitioner to be treated as a candidate in Bengali.
yes. Though casual, but
The
we should.
matter is taken up out of turn in view of urgency as written examination in connection with second state level selection test for recruitment of assistant teachers 2025 for classes 9 and 10 in government aided / sponsored schools is scheduled on 7th September 2025. Stop. Next paragraph. It is submitted by the learned advocate representing the petitioner that while submitting online application form, inadvertently petitioner stated English as medium of vacancy instead of Bengali. English as medium of vacancy instead of Bengali. Stop. Petitioner wants to be treated as a candidate who will fill up OMR.
আর কিছু চাও না, আর কিছু চাও না।
Being treated as Bengali medium candidate. Next paragraph. Who is for the state? State is no. West Bengal Central School Service Commission is represented by learned advocate who submits since petitioner applied under English medium category while submitting online application indicating English against medium of vacancy. in absence of necessary direction from, in absence of necessary direction of court, petitioner is to be treated as English medium candidate. Stop. Having considered the respective submissions made on behalf of the parties, court finds that within time, petitioner submitted application form online, and petitioner, on being found to be an eligible candidate to offer his candidature, was supplied admit card, which is at page 44 of the writ petition. Stop. Next paragraph. West Bengal Central School Service Commission and concerned West Bengal Central School Service Commission is directed to treat the petitioner as
One sentence, if I have just received this instruction, in OMR, there is no place for medium code. So the person can fill up the OMR by relying upon.
no, I am just directing to treat the petitioner as Bengali medium
Exactly.
candidate.
I just made this
Yes.
in the knowledge.
In OMR, there is no classification as such. কি বলছো? As Bengali medium candidate instead of English medium. Next paragraph, writ petitioner says disposed of original observation.
Because in English medium, there is less number of schools. That vacancy.
ঠিক আছে, রচনা রাজি হয়েছে। All right.
Yes.
Item number 25.
What is extreme urgency, Mr. Dotto? That matter is to be heard by 8,
By night, period, I have to respond.
and you have seen my position.
They can respond.
Only court may get some respite after 14, not before that.
This is not maintainable. But this matter can be disposed of.
No, that is not the ground. I am just asking Mr. Dotto that
That, but for some time, you go back to the order.
This is the third round.
why it will not be taken up on 9
But by ninth, period, I have to respond and.
before the state officer.
They have to.
Today, heaven will not fall by on 9. Let to appear on 9.
I have no urgency. My learned friend says that they can wait for 1 week. We go back to the.
But this is the third round of litigation. Third round.
Previous 2 rounds, because both the notices were quashed. And they are after me, they will go on issuing notices.
We'll help you. You are appearing for the
তুমি request. না ঠিক আছে, তুমি করো না।
who is for Union of India?
I am looking for the cantonment.
Cantonment.
It has been issued by the Union of India. Officer of the Union.
And you are for?
Union of India.
Yes, yes.
But the present cause of action is not at page 23A.
Twenty-three A.
Please take the top. Form of notice under subsection 1 and clause DII of subsection 2 of section 4 of the Public Premises Eviction of Unauthorized Occupants Act 1971. Number, kindly look at the grounds. Whereas, in terms of the general law, Mr. GLR, maintained by the Defense Estate Officer, Kolkata, bungalow number 31, survey number 170, telling about 1.38 acres, was a defense land, was an old grant property and governed by GTO number so and so, and as per GLR mutation ID, the recorded holder of rights, HOR is holder of rights,
Holder of
rights
Rights.
was one Khan Bahadur Rustamji Pestanji.
just a minute. Order for yes, Mr.
Holder, the first recorded holder of rights was one Khan Bahadur Rustamji Pestanji of Rajbari, district of Faridpur. As per GLR mutation number so and so, one N.N. Lokit became the recorded holder of rights by virtue of a registered deed of sale, very important, deed of sale dated 23rd of July 1938. As per GLR mutation 1, Shishir Kumar Mukhi became the recorded HOR by virtue of inheritance. And whereas resumption notice was served on the HOR dated GO so and so dated 31/3/1987, and the land was subsequently classified as A1 defense land with a mutation number so and so under management of so and so. Notional, very important, notional handing over and taking over was carried on 30th of April 1987. And whereas it has come to my knowledge that Ramakrishna Vivekananda Mission is in possession of the scheduled property claiming under a lease deed dated 25/5/1983, executed by Shishir Kumar Lokhe, he then HOR who transferred a part of the bungalow onto Ramakrishna Mission Vivekananda Mission, Barakpur, and another part to VVG or WG Education Trust with a lease deed dated so and so without prior intimation, sanction, permission of the competent authority, and WG Education Trust with a power of attorney had given the rights to Ramakrishna Mission Barakpur to bring the subject property. And whereas the state
So this is the history of devolution of the property in
the-
question. Yes.
And whereas the state's premises being government property is admittedly being occupied by Ramakrishna Vivekananda Mission as a lessee under the last HOR without any express permission from the government of India, and the same thus being unauthorized occupation in terms of GTO number 179 of 1836 and Public Premises Eviction of Unauthorized Occupants Act. And whereas liberty was granted by the High Court, will sleep over. Now therefore the pursuant.
So you are representing the petitioner Ramakrishna Vivekananda.
The first is
Just a minute.
yes.
So this is the it appears at first glance, Mr. Dotto, on reading specifically page 24, last but one paragraph, it said writ petition is premature. Why at this stage court will interfere with this notice?
Why will the court interfere at this stage? Because number one, your lordship will not find from this ground as to how the
What would have been the fate of this writ petition if Mr. Dotto would have appeared on behalf of Kolkata Port Trust in these matters?
because I always say that res judicata is not applicable to lawyers, it's applicable to the court. In one matter, my lord, somebody placed a judgment where I appeared for the petitioner and got an order. Now, when I was appealing for the state, someone pulled out that order and said that Mr. Dotto cannot make a contrary submission.
At this stage, please not invite this court to pass an order. And this court is not having regular determination, let it appear on 9 days. I am not satisfied.
Yes, kindly, yes.
I am telling.
But the issue has been settled by division bench. Division has held
moreover, my lord, there are certain stages. My lord, they will be so-called, they will give the reply. That will be hard.
It is
There
also
are-
to some extent known to this court. Yes.
Then, my lord,
Yes,
then
yes,
up
at
to
that
ninth, my
time-
lord, nothing will happen.
For the
And my lord, in
total.
old grant properties,
Yes.
old grant properties, right is presumed from GLR.
This is the problem.
The Supreme Court has said that.
There is a judgment of Justice Dotto at one stage sitting singly with regard to violation of natural justice that was ultimately set aside by the Honorable Division Bench. Mr. Kapoor was appeared in
But amongst
favor of the
others,
Port Trust.
but amongst other, my primary point is that over here in this recital wise will or the notice, your lordship will not find how the central government or the defense became the owner of the land.
How at this stage could at this stage
Because why?
and in pursuance of clause B, II of subsection 2 of section 4, I shall call upon you to appear before me.
Yes. Now, my lord, where
Called, take
cannot
please
decide that.
appear before the estate officer.
my lord,
Place your case.
my lord, before the estate officer, I cannot raise a title dispute. That is the judgment of the Supreme Court. My lord, here your lordship will not find as to how the defense became the owner.
Exactly.
They say that first it was Pestanji, then it went to N.N. Rokhit, then it went to Shishir Kumar Rokhit. Shishir Kumar Rokhit had leased out to me. Therefore, how can suddenly the cantonment board become the owner of the land? And what do they say? That there was a notional handing over and taking over of the property. Can the right
That is
of
subsequent.
can the right of private individuals be taken away through notional handing over, taking over? My lord, your lordships are aware as to how the state become owners of the land. Where the first was Bengal settlement. From there, my lord, it came. Now today, my lord, in modern law, after the British government came, my lord, the Land Acquisition Act was promulgated. Therefore, my lord, if state requires a particular land, my lord, that land has to be acquired through the known process of law. Now, over here, my lord, there is no proceeding wherefrom it can be ascertained that suddenly from Pestanji and all the other persons, the land had gone to the cantonment board or the defense. Number one.
And he is a lessee. And he is a lessee.
Yes, of course, I'm a lessee. Number two is, if he accepts that I'm a lessee, I have a lessor. The lessor is not the estate officer or the defense. The lessor is Shishir Kumar Rokhit. The matter comes to an end over there. Then how can the PP Act on the face of it apply? This is number one. Number two is all lands within the cantonment board, it has been held by our court in respect of Barakpur cantonment itself, does not belong to the cantonment. But this is a misconception that within an area falling under cantonment or cantonment board, all the properties are defense property. It has been held by our court in 1927. No? From 1927, this is the law. Now they will only show what? A GLR. In the GLR, if my property is recorded, according to them, they become the owner of the land. Therefore, my lord, what my
So,
first
did you take any step so far, or the lesser has taken any step so far GLR is as it is recorded in GLR?
my lord, so
No challenge.
No.
my lord,
Till today.
the previous two notices. Please look at the previous two notices.
Have you made lesser as party?
No.
No,
Then
but the notice is against me.
but the issue which you are raising
Yes,
that needs consideration in presence of the lesser,
no, my lord,
Mr. Dotto,
because I can suffer a tenant's estoppel.
because your right comes from lesser.
Right.
So if lesser is absent,
Yes.
court is handicapped to decide the issue.
Yes, now sir, may I say this? Sir? I am not
Order 1
questioning.
Rule 10.
I am not questioning.
Mr. Dotto, I am granting you leave, add lesser as party, let the matter appear on 9th.
My lord.
But in the meantime, give me some protection.
What protection?
Nothing has been.
My lord, kindly see paragraph 12 and 13 of the Supreme Court judgment.
One judgment, I'll show 20 judgments. I have all those. There is only one line
No,
of
no,
one
no.
judgment.
The Honorable
I'll start from
consistently
1927.
consistently.
I rely upon that judgment.
Court knows your ability, that you can continue for a long time. Court knows.
It has been consistently held that
To that extent, there is no confusion. But the thing is, this is the lesser is absent, and your right emanates from lesser.
Yes.
So therefore, lesser were made party.
Notice on
That
the-
Rokshit,
I am being asked.
Shishir Kumar Rokshit,
Granted as a- Lord, I am being.
Lesser is not denying his
still he is alive.
Lesser is not denying his title.
Shishir Kumar Rokshit has died.
So the
Subsisting lease, Malad, they must be paying rent. They must be paying rent.
predecessors in interest of Shishir Kumar Rokshit be made parties.
Successor.
A successor in interest.
Yes, Malad.
But Lord, the proceeding is not against them.
But your right comes from
Definitely.
lesser.
But Lord, who is branded as an unauthorized occupant today, not Shishir or his successor. When
But you can fortify your case if lesser is present.
no,
If they say that we are not.
may I say this, my lord? How does title devolve? Title,
Because GLR says otherwise, Mr.
Yes.
Dotto.
GLR is not sacrosanct. I'll satisfy your lordship. The judgment which my learned friend takes as Bible, he doesn't read the first paragraph of that judgment.
Yes.
But kindly give me some protection.
Yes,
to me,
in the writ petition, notice dated 26th August 2025, issued by the estate officer. Be a respondent number, Mr. Dotto, estate officer.
My lord, may I submit? My lord, may I take leave? My lord,
Yes.
My lord.
Estate, issued by estate officer, station headquarters, Barakpur, being respondent number 5. Is questioned by the petitioner. Stop. While questioning the contents of this notice dated 26th August 2025, Mr. Kishore Dotto, learned senior advocate representing the petitioner, submits. Now, learned advocate representing the petitioner submits a dispute. GLR mutation, relevant disputes, GLR mutation as referred to in the said notice dated 26th August 2025. Next paragraph. Learned advocate representing learned advocates representing the respondents have opposed the prayer, and it is submitted that it is premature. And it is submitted that the writ petition is premature since hearing of this hearing is scheduled before the estate officer on 9th September 2025. Stop. Next paragraph. As it appears from the submission made on behalf of the parties that petitioner is lessee and lesser was one Shishir Kumar Rokshit. Stop. Lesser is not alive today. Therefore, successors in interest of lesser be made parties on amendment of this writ petition. Stop. Learned advocate for the petitioner is granted, next paragraph, learned advocate for the petitioner is granted leave to amend the writ petition and add successors in interest of lessers as additional respondents in course of this day. Stop. Next paragraph. Learned advocate for the petitioner is also directed to serve notice upon the additional respond. Wait, is it possible for you to amend the cost title in course of this day? I think by Monday, yes. By Monday করে দাও, হ্যাঁ, by Monday, comma, 8 September 2025. Next paragraph. After such amendment is carried out, learned advocate for the petitioner is directed to serve notice upon the additional respondents, enclosing a copy of the writ petition and copy of this order by 7 days thereafter, and files affidavit of service on the next date. Next paragraph. At this stage, court is not interfering with the hearing proceedings, which is to be carried out in terms of the interim notice dated 26th August 2025. But outcome of hearing to be outcome of hearing proceedings to be conducted by the state officer shall abide by the result of the report.
And they may appear also. Without prejudice, let them appear, without prejudice.
Sir, I have not made my submissions of I did not close that. And the person is wait for an importer after adding this.
Very.
Kindly try.
না একটু পড়ো আমি ঠিক করবো comma na full stop after amendment is carried out after amendment of post title of this writ petition is carried out petitioner shall be at leave to pay for interim relief before the regular bench. So, list the matter under the same list the matter before the regular bench. It must be after 1 week after effecting service. Then what is the effect of because you won't be able to complete service upon the additional respondent.
Well, then the lessee there
By
must be.
Right. So it is my way. We will do that by
তাহলে ওখানে পড়ো না অ্যামেন্ডমেন্টের জায়গাটা by Monday 8 September 2025 and notice to be and এখানটা চেঞ্জ করবে and notice to be served upon the additional respondents here. তারপরে যা ছিল তাই list the matter before the regular bench on 9. You want on 9? List the matter before the regular bench on 10th September. 9, this court may have determination. So there is no use. Let it be on 10.
Grant them liberty that they can appear without prejudice to their rights. Well,
No, will not appear. If I submit
No,
Without
Mr. Goss
prejudice.
wants to take
Without-
another chance before the regular bench after, because today if this order is passed, then
Yes,
his
I understand.
his case so far at the interim stage is closed. Please.
Yes.
I'm getting.
Good.
Item number 26.
Yes, affidavit service filed on behalf of the petitioner is taken on record.
I beg to honor by state. The report has come from the end of the day. The pattern number 20 kindly see, but DI has not sent. It is in the secretary for leave my letter to file the report.
দাঁড়াও না, পূর্ব বলছি তোমাকে নিয়ে নেবো নাকি? দাঁড়াও। Who is for the state?
I'm happy with the state. The report has come from the end of the day.
So why it is not forwarded to the
Well, current
commission?
to entry, my lord. That was clarified.
I have not called for any
My lord.
report. It is for your consumption.
lord.
Read it, make your submission.
My lord, here, my lord, DI said, my lord, according to my lord, the government guideline,
It is
the
not a
matter-
bail application that you will hand over the
Not
case diary before the court.
not that. My lord, schools have
Yes.
forwarded my lord within 2 weeks from that application, and thereafter, my lord, DI schools had take decision within 2 weeks. But thereafter, my lord, the government notification has come into force. Utsuchi portal has been suspended. My lord, within 7 days.
So suspension of Utsochi portal is the reason.
My lord, for that
This is
reason.
not a reason. Court has decided, division bench has decided.
My lord, up to December 2025, it is my lord,
Distance ground application. Till date, it is lying with DI. Which DI?
Purulia. Purulia.
You will let DI will forward it to the commission and commission will decide in accordance.
My lord, no problem. But DI has said, well, he has no problem. Your lordship direct. My verbally well has said DI.
Issue. Matter is taken up for consideration. Yes.
There are only 3 hurdles as to petitioner has to. One is 10%, another is my lord single teacher.
Petitioners 10%. It is not 10, but a school has forwarded it.
Is school how the school has
therefore
forwarded?
That
So
hurdle is
that
crossed.
hurdle has gone. Now DI has to consider.
Then school could have raised an
Yes,
issue that
yes.
he is not coming within 10%.
10%. Or the DI can
Under
say
rule 5(6).
now if it is pending.
I am not a single teacher. I have stated in my application.
Very well, your lordship will direct the DI to consider and forward it. Consider the case and forward it. I don't know what is the decision of the DI, but let it.
DI will act as a post office.
If it is single teacher, then 3rd January notification will come.
Then the school will point it out.
As you,
School will point it out. There is a
Yes.
single teacher.
Yes.
School is not facing problem.
yes. No,
Why you are anticipating that
No.
there will be a problem?
just because this is on 2000.
DI has no problem.
No. This is
But she said-
2022.
না কি বলছিলাম? Matter is for consideration in terms of the order dated 13th August 2025 in presence of the learned advocates representing the parties excepting school authority. School is not present.
School is not.
Have you made school party? Excepting school authority. Next paragraph. Petitioner made an application for transfer on general ground within bracket distance on portal on 27th August 2022. So, the application, transfer application of the petitioner was forwarded by the school authority where petitioner is presently working to the concerned district inspector of schools AC Purulia. AC Purulia being respondent number 5. So, grievance of the petitioner is, though respondent number 5 received transfer application through portal on 23rd September 2022, same is yet to be forwarded to the West Bengal Central School Service Commission for taking decision. Next paragraph, learned advocate representing state respondent submits due to suspension of portal with effect from 29th September 2022. Respondent number 5 could not forward transfer application of the petitioner to the West Bengal Central School Service Commission. Next paragraph. It is already decided by this court as well as by the Honorable Division Bench that suspension of portal is not a ground to refuse. Is not a ground. Suspension of portal is not a ground for refusing to consider transfer application. since transfer application and since transfer application is required to be processed and decided in terms of statutory provisions. So, next paragraph. Hence, respondent number 5 is directed to forward transfer application of the petitioner to the Chairman, West Bengal Central School Service Commission, or to the School Service Commission, by 7 days from the date of communication of this order. Stop. On receipt of transfer application, respondent number on receipt of transfer application, Chairman, West Bengal Central School Service Commission, being respondent number 4, shall decide the same in accordance with law within 8 weeks thereafter. Stop. Decision to be taken by respondent number 4 shall be communicated to the petitioner by fortnight thereafter. Next paragraph, it is made clear that suspension of portal shall not be a ground to reject transfer application. Stop. Writ petition stands disposed of urgently. Next.
Item number 27.
Yes, yes.
Yes. His service was terminated by the order of Justice 32,000. Ultimately, from the Honorable Supreme Court, it was
Now the matter is under consideration before the Honorable Division Bench.
Now I am apprehending that I will
From the post of primary.
I may be. It is going on, but what is the train? I anticipate that can be target. Now, petitioner participate with the upper primary. Or selected, recommended, appointment letter issued by the board. He could not join within the 9 months. Due to the illness of the father as well as the illness of the and distance also one of the grounds.
Yes. He is petitioner is apprehending that he may lose job. Then what court has to do?
Now petitioners were participating in the upper primary recommended. Appointment letter issued by the board. But petitioner could not join within the 19 due to illness of the father as well as the petitioner himself.
Appointment letter issued by the school.
No, school. No, school করেছে।
It's a recommendation.
Page 7.
The appointment letter issued by the school authority itself after recommendation. Anyhow, he could not join within the 9 Now, pray for extension.
Recommendation is at page 24.
Yes. Recommendation at page 20.
Page 24.
26.
Declaration of selection. No.
26.
Yes, just a minute. 26. This is a recommendation.
Yes. Now, appointment letter on page 27.
Then when you have applied for extension of validity of the
2nd of July.
150 days.
After 100.
Now this is permissible.
Now, in one of the matters, even after considering 17, directed the
That is that the candidate has lost job.
subject to correction. I do not find on the circumstances you are to decide. Probably, I have not found that
Yes.
That is beyond 90 days, but within 150 days.
no, it is not reflected also. Subject to correction also. If they consider my case,
Extension.
পুরো ফেলে গেছে চেঞ্জ করে নিবি নাকি কালিটা এখানটা দিয়ে না
That was before expiry of 150 days. And father of the petitioner had undergone operation.
That is there. One of the reasons are there.
And here you are anticipating that you may lose job. This is not the same situation.
If they consider
You are working.
working, but
No. In anticipation, no order can be passed.
order by virtue of
In
the-
anticipation, you know very well what is the difference so far these two matters are concerned. In spite of that, you have invited consideration of this.
in that case,
That I do not appreciate. You have not joined the other day, Mr. Vishwas. You are not new in this profession. So on reading this order, you know that where are the differences.
difference is
In spite of that, you are placing this order so that court should enter into this. That is not the fair approach.
I-
That is not fair. What are the differences? First of all, petitioner due to illness of father, I have recorded, could not join.
here also
Father had undergone operation. Then what is the second difference? That petitioner was recommended on 25th November 2024. Application was made on 7th April 2025 prior to expiry of 90 days plus 60 days.
in my
You do not understand this.
I special circumstances if your lordship can consider.
Reliance on orders and judgments is always invited. But since you are a seasoned advocate, you should know that which judgment is to be or order is to be placed, which is not to be placed. You have gone through this order, you know that there are differences.
I thought no, it means after 90 days, in my case, it can be considered.
And you have not lost the job.
Maybe,
You are apprehending that you may lose job.
because
Can that be a ground before a court of law?
initially termination
That
of-
in anticipation that petitioner may lose job if special circumstances occurs? Answer is no.
is there. I may come within the purview of 32,000. I may. I leave it.
Issue. You have gone through this order, you know very well where are the differences.
Okay. Your lordship's conscience may permit for
Affidavit of
consideration.
service filed on behalf of the petitioner is, if I allow this, then there will be several other.
Yesterday also your lordship
I have dismissed one matter since 150 days expired. Nothing remains after 150 days. It is not that in an isolated manner I am passing an order in this matter. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Learned advocate representing the petitioner submits. Petitioner on being selected in first SLST 2016 within bracket upper primary was recommended by the chairman West Bengal Central School Service Commission on 17 December 2024 for being appointed as assistant teacher in a government aided secondary school. Stop. Petitioner did not join the recommended post since petitioner was already appointed. Now, since petitioner was working as a primary teacher, So, it is submitted, next paragraph, it is submitted on behalf of the petitioner that petitioner apprehends he may lose job since appointment of the petitioner along with several other similarly placed primary teachers is under consideration before the Honorable Division. However, it is submitted that petitioner is still working as primary teacher. Next paragraph. Petitioner made an application for extension of validity of recommendation dated 17 December 2024. Dated recommendation memo is 17 December 2024. Dated 17 December 2024 on, where is the application?
Page 30.
30. On 2nd July 2025. On 2nd July 2025. Such application dated 2nd July 2025 was submitted, was made. Now, such application dated 2nd July 2025 is addressed to the Chairman West Bengal Central School Service Commission, within bracket short commission, close bracket. And prayer is made for consideration of petitioner's application dated 2nd July 2025 for extension of validity of recommendation in terms of Rule 17(3) of the West Bengal School Service Commission Act 1997. Now, Rule 17(3) of the West Bengal School Service Commission within bracket selection, close bracket, within bracket selection for appointment to the posts of teachers for upper primary level of schools, close bracket, Rules 2016. Follow করতে পারলেন না? আছে মনে। Stop. Next paragraph. West Bengal Central Commission and West Bengal Board of Secondary Education are represented by learned advocates who have jointly opposed this writ petition on the ground. Now, who have jointly opposed this writ petitions as 150 days have already expired from the date of issuance of recommendation on 17 December 2024. It is submitted in terms of relevant provisions of the said rules of 2016 at this belated stage. Consideration at this belated stage, Commission is not authorized to consider application, said application dated 2nd July 2025. Next one. Petitioner was recommended for being appointed as assistant teacher with a memo dated 17 December 2024. But after such a recommendation was issued, petitioner did not approach the concerned authority of commission within the validity of recommendation of 90 days as contemplated under Rule 17(3) semicolon. Petitioner, even within the next period of 60 days, as per proviso to Rule 17(3), did not approach, did not make prayer for extension of validity of recommendation. Stop. Petitioner made application seeking extension of validity of recommendation on 2nd July 2025, when 150 days have already when 150 days already expired in the month of May 2025, in the month of May 2025. Next paragraph. In terms of Rule 17(3), once recommendation is issued for appointment in the post of assistant teacher by the commission, same remains valid for 90 days. And if commission finds it expedient, the recommendation if commission finds it expedient, validity of recommendation can be extended for a period of 60 days, not beyond that. Stop. In the present case, 150 days within bracket 90 days plus 60 days, close bracket, expired in the month of May 2025, and thereafter application was made in July 2025. In the month of July 2025, seeking extension of validity of recommendation. Stop. Next paragraph. Moreover, petitioner is still working as petitioner is working as primary teacher, which was the reason for not joining the recommended post within time in terms of recommendation dated 17 December 2024. Though reliance is placed on an order passed by this court on a writ petition being WPA 1545 of 2025, within bracket Ashim Kumar Singh versus the state of West Bengal and others, but on perusal of the said order, it appears that fact situation was different. And in consideration thereof, direction was given upon the commission to decide application of the petitioner in that writ petition. Father of the petitioner had an operation which prevented Ashim Kumar Singh to join the recommended post, and state petitioner approached the commission seeking extension of validity of recommendation prior to expiry of 150 days. Stop. Therefore, ratio of Ashim Kumar Singh Supra does not come in aid of the petitioner. Next paragraph. In aforesaid conspectus, writ petition stands dismissed. Yes. Side relevant judgments.
Item number
There's a different messages sent that knowing fully well these judgments are being placed. Whenever a learned advocate is placing a judgment, it is also the duty of the court to rely to consider this. So please cite relevant which can be applied in the case at the hand of the court. Yes.
item number 28.
For the petitioner, my lord. Kindly come to page 129. Page 129.
Item page
129.
129. Transfer
On the spouse medical ground, it has reached to the commission. All stages are clear. It is pending at the commission, possibly due to temporary suspension.
120. Just a minute. Let me reach 120.
Yes, I'm sorry.
You prepare voluminous petitions.
I try to give everything
Yes.
for assistance of the court.
Yes, one is an application on
Online transfer.
on which ground?
Our wife's medical ground. It has been allowed, my lord. It is pending at the end of the commission.
Application was made on 9th August 2022.
9th August.
Then it reached DI on 20 August 2022.
Yes, ma'am.
And commission received on 29 September 2022.
It's pending for.
So let it be reconsidered by the medical expert, and if it is found that your transfer application is justified, then it is to be considered by the commission.
Yes, ma'am.
Issue. Matter relates to transfer of the petitioner. Since wife of the petitioner is suffering from gynecological disorder. Stop. Transfer application was made on portal far back on 9th August 2022. And same was considered by the concerned District Inspector of Schools AC. Poshim Medinipur being response number 5 on 20 August 2024. Response number 5, and thereafter it was forwarded to the commission. Stop. Whether you have annexed medical report.
Yes.
What does it say?
Says, my lord, page 51 is the government report from the government hospital.
No, medical report by the CMA.
CMO I do not have. It has been allowed. That's why DI.
That is what I am asking.
Yes,
for.
yes. Otherwise, it would not have been forwarded.
However, medical report based on which respondent number 5 took steps in 2022, took steps in the month in September 2022 is not on record. Stop. Next paragraph. Learned advocates representing the respondents have jointly submitted that after preferring transfer application on 9th August 2022, 3 years have passed. Stop. It is contended due to constant care and treatment, health condition of wife of the petitioner may have improved. Requiring medical examination of wife of the petitioner afresh. Next paragraph, learned advocate for the petitioner submits that wife of the petitioner is ready to be medically examined again by medical expert. Next paragraph, having considered the submissions made on behalf of the parties, respondent number 5 is directed to obtain medical report on medical examination of wife of the petitioner. Obtain medical report ta shudu report. Obtain report on medical examination of wife of the petitioner from concerned chief medical officer of health / medical board by 3 weeks from the date of communication of this order. Stop. In the medical report, TMH / medical board is required to opine considering present health condition of the wife of the petitioner, whether she requires constant care and supervision, constant care and treatment or not. Stop. If medical report justifies transfer of the petitioner, comma, transfer application along with medical report shall be forwarded to the Secretary's party.
Secretary is not a party.
To the chairman West Bengal Central School Service Commission by fortnight thereafter. So, the next paragraph, on receipt of transfer application and medical report, respondent number 4 shall decide the same in accordance with law by 8 weeks thereafter. The decision to be taken by the respondent number 4 shall be communicated to the petitioner by 10 days thereafter. Next paragraph, it is made clear that suspension of portal shall not be a ground to reject transfer application. Stop. Writ petition stands disposed of urgently.
This is the problem now. They are not understanding this.
Vacancies are included in the pool of vacancies related to second list.
Options are given, they are not understanding.
Call the list.
Item number 29.
For the commission.
Here for the petitioner. Transfer. Yes.
But and I was working as a turning back, I made without the water. I applied for the special ultimate my work.
When you met with an accident.
This was on
Date
on 4th of February 2020.
2022.
2023.
See.
However, if your lordship kindly turn at page 14. There was what is by the secretary. That I am going to
Yes.
This letter was replied by the commission.
Commissioner.
আমাকে দেখাও, ওকে দেখাও। রিপ্লাই কি বলেছে?
আমাদেরকে তো প্রোগ্রামে পড়তে দিয়েছে।
In person to the letters mentioned, inform the journal. It has no role in transfer, medical ground of teaching and non-teaching staff of it.
Commissioner has said that commissioner has no role to play. Where is your application?
The application is at page
Page 34. 34.
and the no objection has also been taken by the school authority.
33.
Application for general transfer.
Yes, Malala,
Not
on
medical ground.
on medical ground, Malala, the difficulties, Malala, his representation, Malala, your lordship kindly come to page 37. Malala, to the DI of schools, he has made application. The same application has been forwarded to Malala, the commission and the commissioner of school education and the chairman school service commission. Now, Malala, your lordship will
Now,
find in the
this
subject.
application was made on 1st June 2024, whether you have been medically tested.
Yes, the outside that, I have tested if your lordship kindly.
No, outside testing will not do. Whether the CMOH has medically examined you, where the application is lying.
This application, after this application, this letter was issued by the secretary.
In the letter, he has prayed for administrative transfer on medical ground. That's why Malala, the commission has called.
Now court is considering, since the commissioner is rightly said that he has no role to play. Now, your transfer application dated 1st June 2024, whether it has reached the commission.
Yes, yes. Otherwise, this letter cannot be.
How it can reach? Through DI without medical examination?
That's true.
It cannot.
That is why, I am praying, let it have the medical test by the CMOH. So, if your lordship kindly have a look.
Now, whether the school authority forwarded it to the DI?
I have no instruction, but the school authority has given no objection.
The school authority has given no objection.
Page 30.
Now, whether school authority has forwarded it to the DI?
School authority has issued no objection in the prescribed format.
It is there.
As also separately.
Page 35.
33 the no objection in other format, and in the form also 35.
You are 34 and then 35 no objection.
Yes, objection is there. Whether that offline application has been forwarded or not, that is not clear.
This is also not matter relates to transfer of the petitioner. Affidavit service filed on behalf of the petitioner is taken on record. Take in the next paragraph. Matter relates to transfer of the petitioner. Matter relates to transfer of the petitioner on medical ground. Stop. Petitioner made an application for transfer on 1st June 2024 in prescribed pro forma. And authority of Shampur Bashuli Vidya Bhavan within bracket HS Purbo Medinipur being respondent number 9 issued no objection on transfer application of the petitioner on 1st June 2024. Stop. However, learned advocate representing the petitioner submits that petitioner is not made known whether transfer application was forwarded by the said school authority or said school authority to the district inspector of schools SC Purbo Medinipur being respondent number 7 or not. State respondents West Bengal Central School Service Commission are represented by learned advocates. Stop. It is submitted that stop. It is submitted on behalf of the state respondents in reference to a memo dated 27th February 2025 issued by the Commissioner of School Education. That commissioner has no role to play, or that commissioner has no role to play. Commissioner has no role in transfer of applicant teacher on medical ground. Stop. Memo dated 27th February 2025 issued by Commissioner of School Education West Bengal is placed before this court and same is taken on record. Next paragraph. Having considered the respective submissions made on behalf of the parties, authority of shampoo having parties, said school authority being respondent number 9 is directed to forward transfer application of the petitioner dated 1st June 2024 to the respondent number 7 by fortnight from the date of communication of this order if same is not forwarded till date. Next paragraph. On receipt of transfer application, respondent number 7 shall obtain medical report from the concerned chief medical officer of health/medical board by fortnight thereafter on medical examination of the petition. Stop. In the medical report, CMH/medical board is required to opine, considering present health condition of the petitioner, whether petitioner is required to avoid long distance journey or not. Stop. If medical report justifies transfer of the petitioner, transfer application along with medical report shall be forwarded to the Secretary West Bengal Central School Service Commission being respondent number 6 by fortnight thereafter. Stop. On receipt of transfer application, respondent number 6 shall decide the same in accordance with law by 4 weeks thereafter. Decision to be taken by the respondent number 6 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear suspension of portal shall not be a ground to reject transfer application of the petitioner. Stop.
Now, this is offline application.
Writ petition, offline application. Offline. Writ petition stands disposed of urgent xerox certificate.
Great.
Item number 30.
Yes, is not complete. But you have filed it on 2nd August. 1 month has passed. What is the matter about? Come to the prayer, page 12. Read it. A writ in the nature of mandamus so and so that to consider the candidature of the petitioner for the post of primary teacher. So how this court can take up this matter? But you have not added any concerned or respondent authorities. Commission, School Service Commission has been added as party, has been made as party. Where is the District Primary School Council and West Bengal Board of Primary Education? West Bengal Regional School Service Commission, then Secretary, West Bengal Central School Service Commission. What sort of writ petition is this? And it is filed as secondary education selection process. Your prayer is for candidate to consider candidature of the petitioner for the post of primary teacher. Are you advocate on record? Where is he? Yes? You will never feel well so far this matter is concerned. No, sorry, certainly not. Issue. On perusal of the writ petition, it appears petitioner prayed for consideration of his candidature for the post of primary school teacher. Stop. Therefore, it appears that issue involved in this writ petition relates to primary education. Next paragraph. Writ petition stands released due to want of determination and be placed before the bench and be placed before the appropriate bench. Next paragraph. Learned advocate for the petitioner is granted leave to amend the presentation form.
Amendment advocate on record.
Item number 31.
Why? Typographical mistakes. Primary matter or secondary? At the time of call, learned advocate representing the petitioner prays for leave to withdraw the writ petition with liberty to file afresh. Next paragraph. Respondents are not represented. Next paragraph. Next paragraph. Considering the submission made on behalf of the petitioner, writ petition stands dismissed as withdrawn with liberty to file afresh on self-same cause of action with better particulars. Next paragraph. Parties to act on the server copy. Next. File your affidavit service, open affidavit service.
Item number 32.
And for the state unit.
Yes. Bless your case. When he retired? When she retired?
He retired on 31st March 2020.
Why you are filing writ petition after 12 years?
No, I got
Being the husband?
I got the area pension.
Yes, pension payment order was issued on 31st March 2025. The teacher did not pay for interest. Why husband is paying for interest?
Yes, I got the area pension after around 8 years.
But the pension, when petitioner retired on 31st March 20, not petitioner, wife of the petitioner retired on 31st March 2013. 2013 and pension payment order was issued on 27 June 2013. Where is the delay? Where is the delay?
Not delaying payment of areas of family. We got the PTO in that. After his death, in 22nd May 2016.
27 June 2013, pension payment order was issued. When teacher died?
Died on 22nd of March, May 2016.
So after issuance of PPO, why pension was not paid to the wife of the petitioner?
Due to some minor spelling mistake in the wife.
Her spelling mistake of her husband. Who did this mistake?
The DPPG and respondents.
Where is the relevant document relating to nomination exercised by the teacher?
The teacher filed all the nomination papers.
They show me those documents.
The respondents submission.
No. At the time of serving in the school, the lady teacher must have filed nomination papers.
Yes.
So that nomination papers has to be looked into. Where the correct spelling was indicated or not.
Was correct.
Where is that?
You lost order. That's why they correct.
I am asking where is the nomination papers?
Nomination is lying with the day of
You filed the nomination. Your wife filed the nomination. Why it is not lying with you?
It is with the school authority. It is with the service.
So it has to be seen.
Government has got no
It
right.
has to be seen whether the delay is attributable to the state or not. If the delay caused by the school authority, why state will be fastened with an order to pay interest?
My lord, suppose that mistake of the DPPG.
Now you are receiving, you have received ADR family pension and everything. Yes, sir.
You lost your order. You lost your order dated 22nd of August 2024. And I have got the all the areas.
Yes.
But without interest.
Yes, where is my order?
Page number 1460. Annexure 53.
Yes. কত নম্বর?
Whether the revised pension payment order was issued?
No, my lord, they have correction. They have corrected their reports and released my mention page 20, page 17.
Where the correction was incorporated?
After passing your lordship's order, I communicated the same, and thereafter they called me and corrected it.
Where correction was made? In the pension payment order or the new pension payment order was issued?
No, they have corrected the.
Where corrections were incorporated? In the pension payment, existing pension payment order dated 27 June 2013, or a new pension payment order was issued?
No new pension paper was issued. On the previous one, the first.
Now, this pension payment order was issued on 27 June 2013, containing incorrect spelling so far name of the petitioner is concerned.
Corrected.
So why this writ petition was filed in 2024, previous writ petition? Why approach was not made by the husband of the petitioner or by the wife of the petitioner, or by the why approach was contemporaneous approach was not made by the teacher or by the present petitioner for correction of name as stated in the pension payment order? Because 27 June 2013,
the petitioner why received the pension.
yeah, the quote first. 27 June 2013, this pension payment order was issued. Wife died on 31st March. Wife died on 22nd May 2016. 22nd May 2016.
She has got the pension.
22nd May 2016, and thereafter, what steps you did take? What steps husband did take for correction of the pension payment order? Because as it appears from the
subsequent the written representation three written representations have been made by the husband, the present.
Where are those representations?
That representation, the earlier petition in my.
That is filed in 2024. Earlier writ petition was filed in 2024. But wife died on 22nd May 2016. So from 22nd May, from 23rd May 2016 till 2024, what steps petitioner did take for correction?
For correction, he has made the so many.
Where are those representations? So many.
That was the earlier petition.
Where is it? Today you are seeking interest. Because in previous writ petition there was no prayer for sanction of interest. You have waived your right.
After correction by name, and thereafter they have released the.
In this writ petition, have you annexed any representation?
Representation, my lord, of page 19.
That is after the order was passed in the first writ petition. In between date of the period.
My lord, 10th of July 2025.
Yes, that is the order was passed in the first writ petition. After the order was passed in the first writ petition, but in between date of the petitioner and the order passed by the court in the first writ petition, where are those representations?
Previous writ petition I have annexed.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. His husband of a teacher who died. Petitioner is husband of the petitioner. Petitioner is husband of teacher petitioner is husband of a teacher who retired on superannuation on 31st March 2013. Stop. Stop. After superannuation of wife of the petitioner, pension payment order was issued on 27 June 2013, thereby releasing retirement dues in favor of wife of the petitioner. Stop. Wife died on 22nd May 2016. Stop. It is submitted on behalf of the petitioner. Next paragraph. It is submitted on behalf of the petitioner that in terms of the order passed by this court on the previous writ petition being WPA 20520 of 2024, petitioner was granted family pension. Due to delay caused in releasing family pension in favor of the petitioner by presenting this writ petition, prayer is made for payment of interest on ADR family pension. Next paragraph. State respondents are represented by learned advocate who has opposed the prayer of the petitioner, seeking direction for, or who has opposed the prayer of the petitioner, since it is submitted that delay is not attributable to the state authorities in releasing family pension. Next paragraph. Taking note of the submissions made on behalf of the parties and on perusal of the order dated 22nd August 2024 passed on the writ petition being WPA 20520 of 2024, it transpires that name of the petitioner in the pension payment order dated 27 June 2013 was wrongly recorded. Stop. Pension payment order was issued on 27 June 2013, but previous writ petition was filed in 2024. Stop. Question arises for consideration: what steps petitioner did take after issuance of pension payment order on 27 June 2013 and prior to filing of the writ petition being WPA 20520 of 2024. Stop. in order to substantiate the case made in this writ petition in support of releasing interest as prayed for, reliance is placed on a representation dated 10 July 2025. But same does not come in aid of the petitioner, as the said representation was preferred after the order was passed by this court on the first writ petition on 22nd August 2024. Stop. Therefore, it appears after issuance of pension payment order dated 27 June 2013, steps taken. Now, 27 June 2013, contemporaneous steps were not taken for correction of name of the petitioner in the said pension payment order in the said pension payment order. Stop. Next paragraph. Moreover, at the time of disposing of the previous writ petition being WPA 20520 of 2024, prayer was not made for grant of interest on family pension. Therefore, petitioner is stopped from raising this issue by filing the present writ petition, as same is barred by constructive res judicata. Next paragraph. Hence, writ petition stands dismissed. Arjun Xerox.
Next matter. My lord, one, they have admitted, issued a memo, my lord. They have admitted the prolonged delay.
Next matter.
Item number 33. Lord, I have got the status. Supplementary rewriting নিলে তো হয়ে যেত বোকার মতো
approved resident teacher. She applied for transfer on the ground of the illness of her daughter, who is
praying for
transfer on the ground of my lord, illness of her daughter, Down syndrome patient, my lord, 2.5 years old. She needs special care. But one problem is there. She made formal application, not in prescribed form.
So then you file an application in prescribed form. This court will grant.
And one NOC was also issued, granted by the.
This is also not in form. ওটাও তো তোমাকে ফর্মে
তনুশ্রী কর্মকার। Just a minute.
দিয়ে দেবেন লিবার্টি দেবে লিবার্টি
S44 দেখুন
তুমি আমার থেকে বেশি
S44
গভর্নমেন্টের কথা বলবে না
বলে দিন
তুমি আমার আন্ডারে আছো আমি টাকা দিলে তবেই তোমার আন্ডারে না কি পেয়েছো
Affidavit, file your affidavit service.
টাকাই দেবো
Where is your application
but
for
my
transfer?
Yes, madam. My application that is at page 21, my lord. When I filed it.
Okay.
Before the chairman, page 21, and before the DI at page 20.
Affidavit issue.
And page 44 is the agency by the school.
It is of no. Fresh NOC has to be issued in the prescribed pro forma. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner made an application for transfer since daughter of the petitioner is suffering from ailments. Stop. However, on perusal of the transfer application dated 17th April 2025, which is addressed to the chairman, West Bengal Central School Service Commission, it appears that said application was not made in prescribed pro forma. Next file. Reliance is placed on the order of the Honorable Division Bench, passed on intracourt appeal being FMA 103 of 2025, within bracket Tanushri Kormokar versus the state of West Bengal and others. Stop. In the said order dated 14th February 2025, it was succinctly decided by the Honorable Division Bench that once a thing is required to be done in a particular manner, it should be done in such manner and not otherwise. Stop. The moment form is prescribed in the rules, keeping an integral part of the statutory provisions, comma, it cannot be whittled down, nor to be done away at the behest of the beneficiary of the said rules, nor the other stakeholders of the said rules can dispense with the strict adherence of such statutory norms. তোমার কি পার্টটা লাগবে? আমি তাহলে একটু বলে দিয়ে এই অঞ্জন তনুশ্রী কর্মকারের একটা কপি বার করে ওকে দিয়ে দাও, প্যারাগ্রাফ 5 লিখে নেবে লিখে। Admittedly, in the present case, petitioner has not made application in prescribed pro forma. Therefore, transfer application is not required to be processed. Stop. Hence, next paragraph, hence, writ petition stands dismissed. However, this order shall not preclude the petitioner to make an application for transfer afresh in accordance with law in prescribed pro forma. Stop. Urgent injunction. Yes.
Item number 34.
Service. Matter relating to lordship the family pension to the unmarried daughter.
Respondents,
Everybody.
what is happening?
Who has been also served?
Family pension.
Family pension.
So the state has to be heard. Who is appearing for the state? Are you aware of?
The first time today is happening.
Yes, it was served as it appears. 5th August. Serve notice upon the learned advocate representing the state respondents. Come back. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice, respondents are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing the state respondents by 9th September 2025.
By Monday, I will serve.
Very well. By 8th September 2025. No. Are you appearing in this matter?
No, sir.
By 8th September 2025. Next paragraph. You are appearing in this matter, Mr. Bushman?
Well, I'm for the state.
But so the petitioner's father was an assistant teacher who superannuated from
Father was an assistant teacher.
father,
So you are praying for family pension.
family pension,
Being an unmarried daughter.
unmarried daughter. Now, Lordship, the school was lastly, the initially appointed in a different secondary school, subsequently transferred to Darhotto Rajeshwari Institution. Now, Lordship, the father of the petitioner retired in the year, Lordship, kindly come to my list of dates, 2004.
Date of
30th November 2004.
Yes.
30th November 2004. 30 November 2004.
Yes.
The father of the petitioner expired on when he was getting the pension, 27 November 2017.
17.
Mother of the petitioner, Lordship, when she was getting the family pension, expired on 20th January 2020.
When you have applied.
Now, I have submitted application that is 17th May 2021.
Why this has not been processed? Till
Now,
date?
Lordship, before that, Lordship, before submission of my application for family pension,
I have obtained a self-generated income certificate from the website, which reveals the income of the petitioner is 60,000 per month. Self-generated copy.
Then you are not entitled.
Now, Lordship, let me let's continue.
If it is above 9,000, you are not
My lord,
entitled.
it has been mentioned, my lord, annual income should be
60,000
less
per
than
annum.
42,000. Less than 42,000 per year, my lord. 3,000.
Lordship, let me, it
No,
will be
it has
confusion.
been
Enhanced. Now,
9,000.
in page 109, that has been, the reason was given, my lord, by the DA.
Oh, this has been turned down.
Yes.
Lordship, let me, in my way,
Just,
it will,
it will take
some
long time.
confusion
In
is
your way,
not-
it is not possible. By the motion code to
Page
allow you
109.
long time to state the history.
Now, Lordship,
Just a minute.
this 60,000
I will
per
come to
annum.
the point.
No, Lordship,
Page 100.
109.
Yes. Be precise. Be precise.
Lordship, that because this 60,000 per annum, not per month.
Just a minute.
দেখো এই পরিষ্কার লাইনটা লেখা আছে কোন প্যারাগ্রাফে এটা
নামটা দিয়ে দে। দিয়ে দে, দিয়ে দে।
So you have elder sister. She has to be.
decided by the honorable decision made that if we see, let's see, forego her claim, the younger
She is to be made party. Let me consider whether she has foregone or not.
Yes, she has given the no objection.
লেখা আছে কোথায়?
She has given no objection.
Yes.
Where is no objection? That's why it is important at the motion stage to read first the impugned order. Yes, where she has given no objection.
I think 65.
হবে না
65, my lord.
Several no objections, sir. Kindly come page 65.
That is that.
Clearly goes. To epidemic, she has given no objection.
Objection নিয়ে তো ডিল করেছে।
And I will produce her before your lordship.
No, production is not required.
So far the
What is required is she is to be made party. She is to be made party. Because this no objection is dated 24th November 2020. Whether situation is altered by this time or not, that has to be ascertained by this court.
So by tomorrow lordship, I will.
No, court. Why court will direct? Say read court. Why court will direct?
She is not getting pension. Not only that, lordship. The 42,000 is the limit according to the lordship, the district inspector school. Kindly come to the last annexure. This is a government memo. Page 117.
It was 500.
And 2020 it has been enhanced by the finance department.
2024. এটা 2024 অ্যাপ্লাই করেছিল 2020।
And not only that, lordship, the fine.
Wait. But this is order dated 29th
My lord,
August
I'm getting-
2024.
Yes, he is applied in 2020.
No, kindly come page 116, finance department already enhanced this family pension.
Yes, from 29th August 2024. Where
Kindly
did,
come
what is the
116,
date of your application?
2021.
So then how, at that relevant point of time, you are not eligible.
Kindly-
At best, now you are eligible.
Now kindly come 116.
Now, because it is a case of pension, from the date of your application, you are not eligible.
Kindly come 116.
Yes.
That is the top 270 FPEN. Because 8 September 2021 comment.
Video order is 63 আছে। এইটা অনুযায়ী
Two family pensioners to the children where both their deceased parents were state government employees and state government employees and the state government employees and governed by the WBS DCRB rules. It is not for you. Please don't waste court's time in this fashion. I am asking you why you are inviting this court to look into the document which is not relevant. Please come to the point. 27 enough is enough. 27 September 2024. This decision was this was decided that the ceiling is to be enhanced from 4,000 enhanced to 9,000 per month. So at best from 27 September 2024, you are entitled to receive these benefits. Not prior to that. You made an application for family pension on 20th January 20 when you made an 27th of May 2021. So therefore, if from 27th May 2021, on the date when you have applied, you disclosed that your family monthly income was 60,000. So therefore, on that date, you are not eligible. Subsequently, on issuance of this revised memorandum dated 27 September 2024, whereby the ceiling was enhanced from enhanced to 9,000. Now the monthly income, if anybody's monthly income is 12 into 9,000, and if you are within this cap, then you are entitled. Otherwise, not.
Kindly come 104. For my satisfaction, kindly come 104. This is the certificate issued by the
Pass a new order afresh in consideration of this memorandum dated 27 September 2024.
Keeping all the point, another point is there, my lord, DI's order lordship will find, my lord.
I have received the certificate that my income is 3,000. It was the
No, my lord, if he says so, my lord, kindly his own document, page 60, my lord, kindly takes one, page 660. He has disclosed this document, my lord, wherein, my lord, this has been issued by the BDO.
No, are you disputing that this was not your income?
Writing the
Let it be decided on exchange of
this is the certificate of the DI, the 3,000 income. That is the income of the block development officer issued at 104.
17 February order পরে
This is dated 3rd August 2023.
My lord.
Even after they have again applied, even after that they have rejected.
This is dated 3rd August 2023. When you have applied, you showed your income more 60,000.
So the certificate.
I am asking you on the date of your application on 17th May 2021, whether you disclosed your yearly income 60,000 or not.
60,000 as per the certificate issued by the block developer.
Why you have disclosed it? Now how you can recant now?
Subsequently,
You cannot resile thereafter.
Same block development officer issued the certificate. that my income is 3,000 per
No, no, this is Panchayat Samiti, and that is after the order passed by the DI. Just 2 months that, my lord, this document has been prepared. I think if I say so, my lord. The TI's order is, my lord, 17 to
document
23.
which
Yes,
you
my
are
lord.
relying upon. Now, Mr. Mukherjee, today, if you are disputing this, then issue has to be decided on exchange of affidavits. First, it is required to be decided what is your actual income based on the relevant materials. That is not possible today at the motion stage. Now, if you want, that court can direct the
Kindly direct the DI to consider this on the
uh,
basis of the
along with the cost of rupees 10,000 for wasting court's time.
high level,
Yes.
high level this.
And DI also, my lord, holds, my lord, with regard to that, no objection also.
Yes, obviously, I will proceed. Kindly record my submission. I will produce my lordship elder brother before the concerned GI regarding the note.
No objection cannot applicable, my lord. Kindly see the notification which has been annexed, my lord, 2008, my lord. Grant of family pension unmarried so shall be payable according to their date of birth. Younger of
Page.
my lord, page 110, my lord, kindly text.
আর 114 এর নোটিফিকেশনটা আছে
I will 110.
Page 109, 17 February
My lord,
2023.
my lord, kindly text, my lord. Grant of family pension to the unmarried stroke widows stroke divorced daughters shall be payable according to their date of birth, and younger of them shall get the family pension only after the next above her ceases to be eligible. Now, my lord, she born in 1990, she born in, my lord,
Yes,
in
that is
1991.
That is stated in the impugned order.
Impugned order, my lord. And, my lord,
114
114, my lord, my lord.
নোটিফিকেশনটা
That notification they have annexed, my lord.
ফার্স্ট ক্লারিফিকেশন আর নেক্সট পেজ 150
এটা
ফার্স্ট ক্লারিফিকেশন
Affidavit of service filed on behalf of the petitioner is taken on record. Next, prayer of the petitioner for sanction of family pension was rejected. And you are coming today challenging the order dated 17th February 2023.
Yes, 2023 and.
What you are doing for last 3 years, more than 2 years.
No, subsequently, again, there is a rejection order because I have prepared for review of this order. 17th February.
17th February 2023 order.
Now, subsequently, next page, 111. 8 November 2023. Again, I applied for review of the order.
By changing that income certificate from 60,000 to 36,000.
Block developer.
Whatever you say to the block developer, they can produce. They can whatever I have write down. My income has been from 60,000 to 36,000.
That's why you took so much time to approach this court.
He has not come up before his lordship's court with clean hands.
Paid for review of this matter because block development officer issued after inquiry that my income is 3,000. However, also 2024, there is a notification that
It does not generate confidence in the mind of the court with regard to procuring documents in support of your
state my landed signature is appearing for the block development.
in the writ petition. Order of the district schools SP Hooghly being respondent being memo number 17th February 2023 is under challenge, whereby prayer of the petitioner for sanction of family pension whereby prayer of the petitioner whereby prayer of the petitioner for sanction of family pension was rejected. Stop. One of the reasons assigned in support of taking such decision by the concerned district inspector of schools within bracket AC is petitioner has another elder sister, and as per rules elder sister has got prior right to receive family pension. Stop. Next paragraph. In the writ petition, elder sister has not been made party. Stop.
যেটা কোট করেছেন কেন
unmarried elder sister. Next paragraph. Leave is granted to the petitioner. Leave is granted to the petitioner to amend the cause title of this writ petition. And array unmarried elder sister of the petitioner as additional respondent. In course of this day, will you be able to? In course of this day. Stop. Next paragraph. After such amendment is carried out, learned advocate for the petitioner is directed to serve notice enclosing copy of this writ petition and copy of the order passed today upon the learned advocate. Now, upon the additional respondent by 7 days thereafter and file affidavit of service on the next date. Next paragraph. List the matter under the same heading for further consideration on 18 September 2024.
Prices. My lord, I was there at 10:30 before a coordinate bench, my lord. I could not take leave with this matter. I got this petition affirmed also. This matter pertains to a transfer, my lord. The sole urgency is that the petitioner, being a lady, she lost her husband and her mother within a span of 1 month.
This is not a mentioning time, mention on Monday.
I could not, my lord, because I was there before a court. I humbly, with the deepest of apology.
Sorry, Mr. Bakshi. হ্যাঁ
Before Millard starts, Millard, the order which was passed earlier, Millard, by my lords in the day before yesterday has been upheld by the division bench.
Other matters also they go in for.
I thought, Millard, this is
And as well as before the apex.
already order passed by the honorable division bench.
division.
As well as today, some of the applicant before the apex court also.
Already against this order straight away apex court.
Most
Dismissed.
probably. Yes, most probably.
There were few
Without
matters.
approaching the division bench. That is
Yes. That is from. Few matters, Millard, were listed, but fate I do not
what is
know.
the order till
Not entered.
SLP has been dismissed. Simpliciter. That is what. we have.
against the order passed by this-
Which order I am not informed because my advocate record
না,
informed me
একটা
that
মামলা
some of
dismissed
the
ছিল না?
tainted candidate came before the apex court and my advocate
dismissed.
Oh, acha.
as per my
SLP
instruction over the telephonic instruction. I was not
Division bench has passed a detailed order up
detailed order, yes.
today.
Today.
130.
That's why I hurriedly dictated the
because
order,
otherwise matters
so that you can
become-
get
and
chance
there are few
to approach the higher
Yes.
forum.
Otherwise matters become.
Well,
Yes, in
few
fact,
matters Millard has dismissed today has also been given leave at 3 p.m. with the rider that I will dismiss it in
Came with the memo, I will
dismiss
the
it. It is only to give them an opportunity for.
in these matters, considering the urgencies, there is no time found, it is found by this court to consider the matters in day.
Yes. That is.
Time constraints is there.
Yes. That otherwise some of the reputation become infectious due to time constraint.
Yes, yes.
Malad, this matter already Malad passed the order.
There is change of medium.
Change of medium from English to Bengali. Already Malad.
Previously, it was English to Bengali.
It was history
Where-
from
where is
English
the-
to Bengali. It is mathematics, English to Bengali.
Subject is changed, nothing else.
But in my previous order, I have not indicated the subject.
It's not
Perhaps,
required.
perhaps, perhaps.
Yes, where is your application?
Malad, page number 40.
ওটা তুমি নিয়েছিলে তো?
Page number 40.
40.
Page number?
Application, oh, yes.
Page number 40, medium of vacancy applying for English.
This is your online application.
Of English, medium of vacancy applying for instead of English, that would be Bengali. That is
And
okay.
admit card?
Admit card, very next page, page number 41. And admit card, there is no mentioning about the meeting.
এই না এটা করলে ছেড়ে দিতে হবে না। Urgent matter- Let same order be passed.
Yes, yes, absolutely.
Same order,
Same one.
My lord, may I?
English to Bengali.
Yes.
My lord, may I?
Sarva.
Although, no, all of them, my lord. In 11, 12, because 11, 12 examination on 40, a similar type of matter in 11, 12, my junior will be made.
Monday,
Also in this.
Tuesday, tell her to mention, I will
Yes.
consider.
There's a copy may be supplied.
Yes, yes,
that is.
I'll give that. I'll give that. Similar type of.
Same order, English to Bengali হবে একই।
sorry.
একবার বলো তো একটু সুবিধা। Just a minute, let
Oh,
me-
আচ্ছা, আচ্ছা। Yes. yes. তাহলে সিংহ দাও। Copy
না,
নেবো।
out of front হবে।
আর কপি নেবো আমার কাছে আছে
না, matter is taken up for consideration in view of urgency. না, এটা না ভুল করেছি। As medium of vacancy applying for হবে। না, সব ঠিক আছে। As medium of vacancy দেখো। আবার নালে কালেকশন হবে applying as medium of vacancy applying for আচ্ছা as medium of vacancy applying for as medium of vacancy applying for না medium of vacancy applying for টা কোট আনকোট করা না ঠিক আছে বেঙ্গলি মিডিয়াম
সেটা ধরে
একবার পড়েছেন আস্তে আস্তে applying for medium of vacancy applying for অনিল কুমার ঘোষ প্যান্টটা কেন সুমিত পুরোটাই against medium of vacancy applying for এই পুরোটাই কোট আনকোটের মধ্যে শুধু applying for কোট আনকোট নয় রাইট and in absence of না এটা চেঞ্জ হবে admit by within that page 41 of the document leave is granted to the learned advocate representing the petitioner to communicate this order to the West Bengal Central School Service Commission without waiting for server copy of it. In both the matters. Immediately communicate.
Through email as well as inside.
In this matter, who is appearing for the state? Yes, yes. Huh.
Item number 35 from daily list.
I wish to appear for the well, the petitioner participated in the first SLST 2016 upper primary, in the subject for work education, medium Bengali category schedule caste. And the after result, it is found that the petitioner is disqualified for the calling the personality.
Petitioner participated in first SLST 2016 upper primary. Yes.
And thereafter, the work education. And this result published, it is found that the petitioner is not qualified for the personality test. And thereafter
Qualified for
personality test.
part
Personality test.
personality.
Thereafter, my lord, the petitioner made an RTI application, my lord, just to know, my lord, what marks has been he has, my lord, the obtained, and last, my lord, impanel candidate, my lord, to call for the personality test. And my lord, the page number 69, my lord, the response of such, my lord, the RTI application, my lord.
When RTI application was made?
My lord, 23.
Page 23.
No, my lord, in the year 2023. And page, my lord, the 69.
Already panel expired in 2020.
No, my lord,
2019.
No, my lord, the panel, my lord, the 2000.
When panel was prepared?
December 2018 and expired on
11 December 2019.
he was not called for PD.
11 December 2019. After that, what?
And my lord, 2022, the detailed result has been published on 2022.
22 after expiry of the
My
panel,
lord,
detailed result
because my lord, there was a case, my lord, was
RTI application.
My lord, 69.
Which page?
My lord, page 52, my lord, I details this. My lord, serial number 4, my lord, in bottom, Vikram Mondol, my lord, the date of RTA application 7th of July 2022. First appeal, my lord, 7th of my lord, September 2022. And my lord, second appeal is my lord, this 20th, my lord, December 2023, my lord.
7 July 2022.
My lord.
So that is much after the expiry of the panel, nothing remains.
But my lord, the 2022, the full, my lord, result has been published.
Why?
Published, my lord.
How it is possible after expiry of the panel? What remains?
No, my lord. What remains, my lord? I have been, my lord, informed that, my lord, this I have obtained
to approach the authority within time, within the validity of the panel.
But my lord, due to my lord, the pendency of the proceedings, my lord,
there was no stay, there was no preventive order.
As per my lord, my knowledge is concerned, my lord.
Personality is not communicated with the man. He obtained 73 marks and the last candidate in this category obtained 77 marks.
My lord, 73 marks, my lord, the
total aggregate.
No, 73 I obtained.
For participating in personality test. That is in OMR and academic
mark.
Where we have informed
69 mark. Page 69 mark. Page 69. My lord. Obtained 73, my lord, by fraction, OMR 47 and academic, my lord, 26.
Last candidate or for personality category.
And my lord, may I, my lord, submit the notification, my lord? My lord, in notification,
and the cutoff marks was 79.
77.
Second one.
77. May I submit one thing, my lord?
On behalf of the petitioner is taken on record. Next page.
My lord, the academic score has not been calculated properly. My lord, that is why, my lord, this in page number 25, my lord, the manner of the evaluation.
Okay, it is too late in the day. Sorry.
And my lord, academic score, I have got 78.
Affidavit service filed on behalf of the petitioner is taken on record. Next page. Petitioner participated in first state level selection test 2016. Upper primary for work education and physical upper primary. Again within bracket work education and physical. 2016. Now, first SLST, first step level selection test 2016 within bracket upper primary, within bracket work education physical education. But the petitioner was not called for personality test. So, on being agreed, petitioner filed present petition, praying for certain directions. Upon the concerned respondent authorities, which would permit the petitioner to be considered afresh in connection with aforesaid selection process, namely first SLST 2016 upper primary work education physical education. Next paragraph, it is pointed out on behalf of the commission that in response to RTI application of the petitioner, he or she was informed that that petitioner was awarded 73 marks, whereas cutoff marks fixed for participating in personality test under the category of the petitioner was 73. 77. Next paragraph, it is also submitted that panel in connection with aforesaid selection process was prepared on 12 December 2018 and with 12 December 2018 and same expired on 11 December 2018. Next paragraph, having considered the respective submissions made on behalf of the parties, it appears, taking note of the marks awarded to the petitioner in the aforesaid selection process, that petitioner did not come within the zone of consideration for participating in personality test. Stop. Petitioner was awarded 77 marks, where petitioner was awarded 73 marks, whereas 77 was fixed as cutoff marks under the category of the petitioner. Next paragraph.
Well, my academic score wrongly calculated. That is my problem.
Stop. However, it needs to be recorded that calculation of marks which was awarded in favor of the petitioner is disputed by the learned advocate representing the petitioner. Next paragraph. In connection with the aforesaid selection process, panel was prepared on 12 December 2018 and same expired on 11th December 2019. So it is tried. It is tried that after expiry of the panel, right of the candidate to question selection process does not right of the candidate to question selection process gets to question selection process is withered away. So in this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 1996 9 SCC, State of Uttar Pradesh and others versus Harish Chandra and others, and another judgment reported in 2009 to SCC 706, Girdhar Kumar Dadich, and another versus State of Rajasthan. Next one. Hence, writ petition stands dismissed. Urgent xerox. Next.
Service. So service.
Item number 36.
Matter pertains to extension of recommendation in respect of upper primary selection process. Extension prayer has been made within before 140 days, beyond 90 days, but within 150 days. 137th day it has been made.
Extension for
Recommendation.
extension prayer for validity of
Validity
recommendation.
of the recommendation. And it is
When
not
the prayer was made,
Prayer-
after within 90 days or within 150
No, no,
days or
within-
beyond 150 days.
within
There are three categories.
Yes, within
Yes.
beyond 90 days, but within 150 days.
Why you could not join?
My lord, I am the teacher of assistant teacher of primary level. My lord, there is, my lord, after 3rd April, my lord, whole scenario you have seen. My lord, I am facing the litigation in respect
You
of.
may lose job in future. That's why today court will exercise its discretion.
My lord, I'm not discretion. My lord, it is not
What
discretion.
prevented the petitioner to join the post of assistant teacher? It must be far away because you are working in a primary school and it's a job in secondary school. What
My lord, I
prevented
am
you?
only seeking, my lord, it is the rule 17.3, they has the power to take decision. My lord, I made a prayer, I am seeking only they take a decision. Since my representation application is pending before that, it has not decided it, and it is within 150.
You will first recommendation was issued. It's not a case of job loser.
No,
First recommendation was issued. You did not join. Then 90 days expire. The recommendation recommendation ceased. After cessation of recommendation, you are coming that my application. You made an application seeking extension, and that should be considered.
My lord, only, my lord, as per the statutory provision, it is, my lord, 90 days validity, but special circumstances they can extend.
No, that special circumstances does not exist here. I could understand if you would have applied for extension of validity of recommendation within 90 days. After 90 days, there is a natural date.
That's
If after natural date, what is the scope?
My lord, after that,
Only
but
court
they
is
have
exercising its extraordinary jurisdiction in consideration of special circumstances. That circumstances is not present in your case. It was a case of a job loser. Then this court passed certain orders.
That is not.
That is not that. Then after the natural death, why court will pass an order?
My lord, since, my lord, statutory provision, my lord, they
I
can.
could understand if you would have approached the court within 90 days.
No, my lord, it is
What
not.
is the law under 17.3?
17
That it will remain valid for 90 years.
days, but
After
special
that, there is natural death.
After
After natural death, when it is dead, it cannot be oxygen cannot be pumped into it.
But my lord, they
No,
can.
you are an advocate of the High Court, so you have to think logically.
Yes.
So when this recommendation is dead, a dead recommendation cannot be made alive.
Made alive, but my lord, up to my lord, they can.
Only in certain circumstances where petitioners are job losers, court exercise its special its power, its discretion. But that circumstances is not available here.
Available here, that is not. But my lord, there is some. I have specifically stated in my.
When you made application?
Yes, my lord. On my lord, on 7th April. After 3rd April, my lord, since 32,000. Job, my lord, that litigation is pending before the honorable. Everything scenario has changed. My lord, this is I have stated in my categorically. I am facing that process. Page 24, my lord, I have stated. মানে প্যারাগ্রাফ নাম্বারে বর্তমানে আমি প্রাইমারি স্কুলের অ্যাসিস্ট্যান্ট টিচার বর্তমানে আইনি জটিলতার কারণে
could have directed had you approached the authority within 90 days. Beyond 90 days time already,
but
the recommendation
extension
ceased to exist.
But some extension 150 days they can. Up to 150 days they can.
150 days, then no, that is not the law. Law is this, that for 90 days it will remain valid. If commission finds it expedient in by recording reasons, commission can extend for a period of 60 days. But that exercise is required to be done within 90 days.
But that
if that exercise, suppose the exercise is not made by the commission, there is a natural death of recommendation.
But it can be revived.
No, provision doesn't so. You read it properly. You read it.
But I am
January. In the month of February, this 90 days expire.
Yes, 90 days.
And even after expired of 30 days in the month of April, you March, April.
Yes, 137 days I made a pay. But after 3rd April. After 3rd April.
Sure. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner prays for extension of validity of recommendation dated 21st November 2024, which was issued by the chairman West Bengal Central School Service Commission. Since petitioner was selected in first state level selection test 2016 within bracket upper primary. The VDA said recommendation dated 21st November 2024. Petitioner was permitted to join the post of assistant teacher in a government aided secondary school, but petitioner chose not to join the post. Subsequently, petitioner made a prayer with a letter dated 7th April 2025 seeking extension of validity of recommendation dated 21st November 2024. Next paragraph. Prayer of the petitioner is opposed by the learned advocates representing the respondent authorities due to expiry of 90 days. Opposed by the learned advocates representing the respondents on the strength of Rule 17(3). Of the West Bengal School Service Commission within bracket selection for appointment to the posts of teachers for upper primary level of schools close bracket rules 2016. It is submitted after expiry of 90 days from the date of recommendation, comma, said recommendation does not remain alive, or said recommendation does not exist. Therefore, application of the petitioner dated 7th April 2025 is related application which may not require consideration. Next paragraph. Petitioner was selected in first SLST 2016 upper primary and was recommended with a memo dated 21st November 2024 for being appointed in a government aided secondary school, but petitioner did not join the recommended post. In terms of Rule 17(3) of the Rule 17(3) of the said rules of 2016, once recommendation is issued, same remain alive for a period of 90 days. After expiry of 90 days, recommendation ceases to exist. Stop. In the event recommended candidate finds it difficult
to join the post within the period of 90 days, said candidate is required to apply for extension of validity of recommendation within the period of 90 days, not beyond that. In the present, next paragraph, in the present case, petitioner applied for extension of validity of recommendation on 7th April 2025, whereas 90 days expired on 21st, on 20th February 2025. At the time of making application seeking extension of validity of recommendation, at the time of making application on 7th April 2025, seeking extension of validity of recommendation, comma, said recommendation dated 21st November 2024 expired. Stop. Moreover, next paragraph. Moreover, it appears that petitioner is working in the post of. Moreover, it appears that petitioner is working as primary teacher. Stop. Hence, prayer of the petitioner for consideration of application dated 7th April 2025. Seeking extension of validity of recommendation is rejected or is refused. Stop. Writ petition stands dismissed. Refused korbe.
Item number 37.
What is the matter about? What you have prayed for? From which date you are not getting salary?
I am not advocate on record, my lord.
Yes?
I am not advocate on record, my lord. The Devasis will be the advocate on record.
Where is it?
It's another court.
Another court. And the service is not complete. If service is not complete, 4th of August filing while why date is given, that matter to be listed on a particular date. Yes, sir. At the time of call, accommodation is paid for. Since service upon the learned advocate, you are appealing. Since people at time of call, accommodation is paid for. Since service upon the respondents is not complete. Next paragraph. List the matter under the same. Land advocate of the petition is directed to complete service of all the respondents by 10 days from date and file affidavit of service on the next.
Yes,
great. List the matter under the same heading for further consideration on 28 October 2025. Next.
Item number 38.
My lord, this is also
Same primary teacher.
primary teacher, but petitioner approves to the DI. For petition of recommendation.
DI is not the authority.
But my lord,
DI has no
my lord,
authority.
petitioner is differently able person.
Maybe.
Petitioner is somebody.
For that, no separate rule is there.
No. But mother at the
Petitioner is working as primary teacher. Very well. Come back on next day. Let this order be transcribed. Rely upon this order, Mr. Rai, on that day. Not today. Let me see.
Service time.
Otherwise, on same issue, one after another order has to be passed. Placing reliance, I will pass them order.
Item number 39.
On repeated discussion of 17th.
39, for petitioner.
Not today, not today, page ye just a minute, is 38 holo to otta Ghosh Choudhury 38, not today kore rakhun. Yes, 39, yes. Why?
Read by Mr. Sotipata Jana.
What is the matter of it? You don't want to place this case. Your senior will get angry if you place this case.
Lakshmi, kindly come to page.
Just a minute. He's paying for time. Issue. At the time of call, accommodation is paid for on behalf of the petitioner. Stop. However, state respondents is represented by. Next, the hearing of this matter stands adjourned. This is the matter for further consideration. On 29th October 2020.
Great.
Next.
Item number 40.
Advocate on record is not well, my lord. I am praying for not to.
Taking rest at home. You are all here at court and your advocate on record is taking rest. Yes. What is the prayer made, Mr. Acharya? Medical examination is prayed for?
Under medical.
For what? Transfer?
But that has been turned down for my lord earlier order.
Not today. Next.
Number 51. I am appearing for the petition.
I am for the secondary board.
The petitioner was appointed as assistant teacher in Dugdia High School way back in 2005.
In
Dugdia High School in 2005. Now, my lord, his service was approved by the DI. He applied for general transfer. Transfer was allowed. He joined the new school in 2021. My lord, till date, the service book has not been transferred from
by the
Artsville school to the
who is
present.
appearing for the hostel?
My lord, I have served everybody.
Yes.
I have served all. My lord. Only prayer is, my lord, to release my service book. There is no proceeding pending. The release order issued by the Artsville headmaster is also in my favor. Page 20.
When you have served upon the school authority, fine.
My lord, yes. The 8th of July, 8th, 7/8/2020.
7th August.
My lord, kindly seize page 20, my lord, the release order. There is no allegation against me.
Where is the acknowledgement?
My lord,
Where is the tracking report?
My lord, I have taken the tracking report separately. At that time, postal problem was there. My lord, I have taken it separately. My lord, all I have received.
File a composite affidavit of service because since your main grievance is against Dugdia High School.
Yes, ma'am.
And they are not represented.
Well,
so that's why serve further notice and file a affidavit of service.
My lord.
Showing service of notice on previous occasion and in
my lord, only to the school, my lord.
Yes, state is represented.
Yes.
I am for the secondary board, lord.
Board and state is represented.
Only
So
to
only
the school.
and your grievances against the school.
Yes, my lord.
They are 7, 8 and 9.
Respond 7, 8 and 9.
And 6 is the present school.
Present school. Shedbagan school.
He may not,
They-
may not be represented.
Yes, yes.
Present school may not be represented.
But I'll serve the
7,
headmaster.
8, 9 requires representation.
My lord.
Otherwise, court has to pass an order ensuring their presence before this.
My lord.
Issue. Affidavit of service filed. Take back this affidavit of
My
service. This affidavit of
My lord, I
service
shall
will
file
not
a
be-
new one. Yes.
It is out. Petitioner, learned advocate representing the petitioner submits. When you were transferred,
My lord, I was transferred in 2021.
when is your when you joined the present school?
My lord, present school, my lord, 24/11/2021, my lord, page 21.
This is the approval memo.
Approval.
Submits that petitioner joined the post of assistant teacher in Shedbagan Adorsho Vidya Mandir, Kolkata on transfer.
No, my lord, this was my, yes, on transfer. My lord, extremely, sir. My lord, extremely, sir. My lord, I am sorry.
On transfer on 24th November 2021. So, prior to that, petitioner was working in Dugdia, Altadanga High School within bracket HS, not 24 Parganas, being respondent number 7, 8 and 9. Stop. Grievance of the petitioner is, in spite of obtaining relief from Dugdia Poltadanga High School within bracket HS and joined the post in the present school on 24th November 2021 in terms of transfer order issued by the concerned respondent authority, first school authority, till date have not till date has not forwarded updated service book of the petitioner to his present school. Next paragraph. Considering the grievance of the petitioner, representation on behalf of Dugdia Poltadanga High School within bracket HS not 24 Parganas is required. Next paragraph. Learned advocate for the petitioner is directed to serve notice enclosing copy of this order upon Dugdia Poltadanga High School within bracket HS being respondent number 7, 8 and 9 by 10 days from date and file affidavit of service on the next day. Next paragraph. List the matter under the same heading on 22nd September 2025 for further confirmation. Next paragraph. It is made clear if in spite of service of notice, authorities of Dugdia Poltadanga High School within bracket HS is not represented on the next date, appropriate order shall be passed ensuring representation on behalf of the said school authority. So, grateful. Next.
But the respondent would be 8 and 9.
7, 8, 9.
7, my lord, the present school. 8 and 9.
Eight.
Grateful, man.
Right. It is present school. Next.
Item number 42.
This is with respect to a transfer of the headmaster. When he makes this application for the affidavit of service, but yes, when he makes this application for transfer on the ground of distance offline in the prescribed perform.
And my lord, he makes his application because he is the head of the institution, makes his application, and my lord, the president of the managing committee grants the NOC to that. But my lord, the school authority, which is president, they are saying, my lord, because of this portal is suspended, they cannot forward it to the district inspector.
Managing committee.
So my lord, in spite of granting NOC,
Where is your application for transfer?
Lordship kindly sees at page number 25 of the writ petition. And my lord, I'm sorry. And my lord, 28 is my lord the relevant.
No objection has been granted.
Page number 28.
ये कौन? Cap कोई दो.
It's the page number 20. I'm sorry. No, no.
No date is there.
My application's date, your lordship will find at page number
9th May.
26, yes.
Now, but after granting no objection, school is not forwarding it.
But I have served upon the school.
When you have served upon the school,
Received my lord on 18th. But may I just hand up to your lordship the page number of the relevant. 18th, my lord, they are delivered.
18th August.
18 August.
May I hand up to your lordship for your lordship the page.
Serve another notice. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, in spite of service of notice, Shadapuli Surendranath Vidyaniketan, Hubli, being respondent number 6 and 7 are not represented. Next paragraph, learned advocate for the petitioner submits an application for transfer was made in respect pro forma on 9th May 2025. And the aforesaid school authority granted no objection for transfer of the petitioner, but till date, transfer application has not been forwarded in offline mode to the concerned district inspector of schools AC Hubli, being respondent number 5. Next slide. Since grievance of the petitioner is against respondent numbers 6 and 7, learned advocate for the petitioner is directed to serve another notice enclosing copy of this order upon those respondent numbers 6 and 7 by 7 days from date and file further repetitive service on the next day. List the matter under the same heading for further consideration on 16 September 2024. All the fixed matter.
Item number 223.
আমার চেম্বারে পাঠিয়ে দিবেন।
And I appear for the petitioners, your lordship.
Order, please.
My lord, Mr. Mojumdar is on his way. My lord, till my senior comes, my lord, refuting the submissions of the state respondents and KMDA, we have prepared one additional note, my lord. We have, my lord, when all the points in
Which
submission.
additional reports?
My lord, additional notes of the writ petitioners refuting the submissions made by KMDA and state respondent on the last occasion, and also the judgments which have been cited by my learned seniors. My lord, those judgments have been dealt with. And my lord, additionally, 2 judgments, your lordship, I have enclosed.
Give, make your submission, what you want to submit in reply. Be quick. You know that I have to rise at
Lordship.
3:15. Try to finish it off.
My lord, kindly comes to page 138. The lordship had indicated this, my lord, particular page which was issued by KMDA to the Joint Secretary to the Government of West Bengal.
Yes, yes, yes.
My lord, 138 of the writ petition. My lord, this page was also indicated by my lord, whereby my lord, the KMDA issues a letter to the Joint Secretary of the Government to the West Bengal. My lord, may I read for you, my lord, para 3. It appears that the retired employees of KMWSA who have passed over 15 years after retirement but did not get the benefit of restoration alike to the state government employees, although the annuity value has been fixed on the basis of 15 years
Yes.
span. My lord, so there apparently there was already an admission on the part of the KMDA, and now, my lord, on the previous occasion, my lord, they had contradicted their stand. We did their reports and, my lord, the submissions. Next, my lord, kindly comes to page 160. My lord, the page number 160 reflects.
Yes, yes. Continue.
My lord, page number 160 reflects one document wherein KMC, in view of the, my lord, may I read, with due consideration to the memo dated 19th August 1987. My lord, this memo I have annexed. My lord, I'm coming to that memo. Read with memo dated 26th April 1990 of the Government of West Bengal Finance Department Audit Branch, Honorable Mayor, by his orders dated 12th November 2010, has approved restoration of the commuted portion of pension to a KMC pensioner after completion of 15 years.
Without any amendment.
Lordship, without any amendment. And also the the revision of 33% to 40% was also without amendment, my lord. Madam, let the
Give him some time.
my lord, that was also without
is
any
right?
amendment.
Yes.
And my lord,
But I have prepared a note, not
Yes.
replying to the argument of the state and the KMDA. And it's merely repeat. I would be repeating my same submission once and again. So not, I have only not referred.
Take 2 minutes.
No, time is running out. 3:15,
Yes.
your lordships have to rise.
And I want to finish it.
Finish it off.
Nothing remains. I have heard all the parties extensively.
Only 2 judgments I have cited in reply apropos the argument advanced by.
On which proposition?
Not one is, what is the effect of an executive function vis-a-vis the legislative jurisdiction? But executive function is the residuary of the judicial and legislative functions. And there is a law, regulation in KMDA, CMDA, DCRB rules, regulations. But that is an interpretation of the rules. I don't need to challenge that any further. 51 or 52, which one will apply? But I have enclosed the regulation 30 of the West Bengal Commutation of Pension Rules for your lordship's convenience at page 12.
Yes, it is there. It is also annexed to this to the writ petition.
I'm not. If there is any scope of interpretation, which way will it prevail? It's always the weaker section where in whose favor the interpretation should go.
And
Most
matter
of
relates to
Article 21.
Restoration of
Pension is part of Article 21. And only if not that calculation I have tried to explain, although I have submitted that orally. Please come to paragraph.
9 years, 12 years, then 15.
Yes. Please come to paragraphs 12 and 13
of your written note.
Of the supplementary written notes.
12 and 13.
My lord. Kindly recollect the report filed by KMDA. Two calculation was shown, one with reference to monthly commutation, the other was with reference to year. But the annuity value is the number of years by which not the principal gets repaid. And older is the person.
But there is no document from which this formula can be.
But that is not very difficult for us.
You are making submission, you are pointing it out on last 3 or 4 occasions.
Not when.
But I have also tried, but I haven't found any.
It was done long time back. Not your lordship kindly records that page 9 and 10 of that affidavit filed by KMDA. Page 10 had a reference to LIC.
That's why
annuity.
court cannot bank upon it by making a specific observation since it is not on record.
I'm only trying to draw a logical conclusion therefrom.
That I follow, but yes, there is that it is this 9.48 denotes years.
Yes.
Years for recovery of the amount which is paid to the petitioner.
Principal amount.
Then up to the 12 years is interest is to be paid, and you are saying from 12 to 15 years.
That's the prospective loss.
Yes, to recuperate prospective loss. This is the formula.
But this is what the actuarians or probably the statisticians had evolved.
And these 2 judgments which you have, this judgment 1955 SCC on what?
That is the executive function is the residuary of judicial and legislative function. No, that's a constitutional bench judgment, but it's a well propounded.
Which paragraphs?
Paragraph 12. 12 and 13. Paragraph 12.
Yes, sir. Hearing concluded, judgment.
Grateful to your lordship.